Satya skills. In this video, let us learn something about Memorandum of Association. Memorandum of Association represents the charter of the company. Remember, charter means something legal. Okay, it is a legal document prepared during a company's formation and registration process. It defines the company's relationship with shareholders and specifies the objectives for which the company has been formed. The company can undertake only those activities mentioned in Memorandum of Association. Memorandum of Association is a document of great importance for the proposed company. It contains all fundamental conditions upon which the company is incorporated. It lays down the operation of the company. I can say that various activities of the company are prescribed in MOA and company cannot go beyond that. When company's actions go beyond MOA, they are void. Void means no validity for those activities in the eye of law. Okay, therefore, it is the foundation base for the company to be established. Okay, memorandum of a company shall be printed, divided into paragraphs, signed by the subscribers. It is a public document and is available to anyone who is interested in the particular company. Shareholders of the company need MOA to know about their rights and powers and other related restrictions. Okay. Section 3 of the Companies Act states that MOA should be signed by at least 2 subscribers in case of private company, 7 in case of public limited company, 1 in case of one person company. A company can be registered only when MOA is drafted in the prescribed format and signed by the members as given in the Act. Section 4, subsection 6 of Companies Act 13 give the format of MOA in Table A to Table E of Schedule 1 of the Act. A company can select suitable format given in the Act. Okay. Now, what a memorandum contains? It contains certain clauses. The first one is the name clause. Name clause is under section 20 of the Companies Act. The name of the company is important symbol for existence of the company, like a name to a man, name to the company. A company may select any suitable name subject to the following rules. A company cannot register by a name which is too similar to the name of another company. They cannot copy it. Okay, it should not be a misleading name. Memorandum shall state the name of the company with limited as the last word of the name. The emblems, names, prevention improvement, that's improper use of use Act 1950 prohibits the use of any name specified in the Act. For example, like UNO, Central Government of India, like that. The registered office clause, every company shall have a registered office. All communications and notices are to be addressed to that registered office and all details are to be given. Then objectives clause. This is very important. The objects of the company shall be stated clearly in the memorandum. This clause enables the persons to know about the scope of the company. Objects clause shall state main objects of the company and if there are any other, that also. Next one is the capital clause. Memorandum shall state the amount of share capital with which the company is to be registered. It also shows number of shares. The capital is called registered capital, or we all usually call it as authorized capital or the nominal capital. Remember, it's very important, you will get in competitive exams. Registered capital or authorized capital is the maximum limit up to which a company can issue shares. Okay, so that is called authorized capital. Okay, from this authorized capital, whatever is taken by the company to issue shares to the public, they are called issued capital. Whatever is subscribed by the public called subscribed capital. How much amount they pay, the shares may be half or full, that is called paid up capital. Remember, paid up capital is shown in the balance sheet, not other capitals. Maybe other capitals you can show in the outer column, but final column you have to show only the paid up capital. Okay. Now, next one is the liability clause. The memorandum shall state that the liability of members is limited if it is a limited company. Naturally, association clause contains names and addresses of the shareholders. Then alteration. See, actually memorandum is a legal document. It cannot be easily altered, but it requires lot of what I can say is that resolution. It has to be passed in the board's meeting, etc. So it is a very difficult, and a few things they permit, like a name they can change the office, registered office. They can change limited to maybe private limited to public limited, like that few things are there. But the alteration of objects is subject to the physical limit and procedural limits that they have to consider. Special resolution shall be passed at the general meeting to alter the objects of the company. Is very important. Company shall file the resolution with registrar, and registrar certifies the resolution. That's all in this video. All the